we are tabling whether or not these matters need to be tried together. That will only be known once we have full understanding of what comes out in discovery.
And I can understand Ms. Reed wants to be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
Do it. Knock yourself out.
The judge in the lawsuit filed on behalf of Paul O'Keefe's estate had a Zoom conference, and the hilarious thing about it was anyone could just join in, and you'll see various people just popping up during the conference.
Uh-oh. I think we're going to have to go without the light. We think that we should combine these things because otherwise we're going to take 2 depositions for every single person.
You agreed to come out to my show, so I'm just extremely grateful, and I very much appreciate you joining.
You're far too humble. You do a great job.
This is Alan Jackson. You may remember him from the Karen Reed trial. He's agreed to do an interview with a fellow law tuber. Let's watch.
One of the things I've always admired about your show is that you dig into the details, and I think oftentimes that's what's missing.
How's Karen doing?
She's great. She's doing very, very well. She knows that she's got another
Let's hope Alan can use some of that GoFundMe money to get a better internet connection.
Fight on her hands, but she's got her back up and she's ready to take it on.
I just saw recently that there's this opposition, this non-party, Jennifer McCabe, Matthew McCabe, Nicole Albert, all those guys, all the gang, their opposition, and then them hinting that they're going to file a defamation lawsuit against Karen and a certain blogger. When are they going to leave her alone?
The turn of events that occurred on at the last hearing, the Zoom hearing that we had.
Your Honor, actually, I don't know what he's talking about.
The judge in the lawsuit filed on behalf of Paul O'Keefe's estate had a Zoom conference, and the hilarious thing about it was anyone could just join in, and you'll see various people just popping up during the conference. Let's watch.
Karen's statements have been consistent, and they're certainly consistent with the lawsuit that's been filed in Bristol County.
Talking about that exact thing. Are the cases going to be consolidated? Because she's getting up on the balls of her feet. She's actually suing individuals. She's not just going to sit there and be on the defensive. She's going to be on the offensive. She is now on the offensive. There are other parties that are going to end up being brought into the case. It's her case as well.
Because Karen was sued by the estate of John O'Keefe for causing his death, she tried to have all the parties for which she wants to sue consolidated into that case. She initially received some opposition. Therefore, they did the smart thing and just filed the lawsuit in a separate court.
The original thought was it makes sense because all the same parties, all the same evidence, all the same arguments are going to be propounded in either one of the cases. In both of the cases, they should be combined. It made sense to combine them. The civil lawyers, Damon Seligson, when he made his first introduction about this issue to the judge, he said as much and said, our intention with the court's permission is we think that we should combine these things because otherwise we're going to take 2 depositions for every.
Oh no, and now Alan's electric went out.
Every single person, I think a light just went out.
2
depositions for every single person that is on the witness list, and all the discovery is going to be duplicated. So it doesn't make any sense. That said, I think we're going to have to go without the light. That said, it didn't make sense for us to do this separately. So we made the pitch. The next thing you know, they oppose it in the opposition that you're talking about. So we said, okay, fine. Then we'll just sue individually. We'll sue in a different county and put on an active lawsuit that is to our liking. She becomes the plaintiff. These individuals that have been named become the defendants. Well, the next thing you know, we go back into court, and the argument that is then propounded by opposing counsel is, well, wait a minute, why aren't we putting these things together? Which is exactly where we started from. So I felt like I was a little bit in Alice in Wonderland.
I do expect that we will convene a 9C amongst all the parties after this to discuss what efforts, if any, will be made to consolidate discovery.
This is Mark Diller, the attorney representing the O'Keefes in the initial filing. Now, on Friday, he's claiming that he wants to consolidate some of the aspects of both lawsuits into this one.
On the other pending matter, only to ensure that we not worry about there being information that is discovered in the other case relevant to our case, which would prejudice us if we're not privy to.
It's great you're trying to agree to something, but again, I think it's difficult to have an agreement without knowing who's going to be involved in the other case. What's the status on the service on the individual defendants in the Bristol case?
I haven't received information where we've gotten good service, and if we've not gotten it, I expect to get it shortly.
That's the judge inquiring about the status of the Bristol case. The Bristol case is the case Karen Reed filed separately, and he's inquiring as to whether any of the defendants have been properly served yet.
Attorney Diller, you talked about consolidation. Attorney Waters said they weren't going to move it this time. You, Attorney Diller, intend on moving to consolidate?
The answer is yes, for purposes of discovery only, just to the extent that that works itself out.
This is what Alan was referring to our favorite Jewish law trooper. Here, the attorneys for the O'Keefes are saying they are in favor of consolidating, despite the fact that they put up such a huge opposition when Karen made a motion to have all of her claims in this very case.
There was discussion during that entire motion practice that took place over the last 2 months. The counsel for these other parties had all reached out. I have the briefing from those counsel. There was discussion within some of the briefing that it should be consolidated for purposes of discovery purposes. You know, obviously we had wanted this to all resolve itself months ago, and unfortunately it wasn't until Monday night that the defendants withdrew their motion and started on a different track with a different mindset. We will happily be proactive in trying to get that moving in the best direction for our case in the wrongful death case. Well, what I don't know, Your Honor, is whether some of the parties are going to move to dismiss in the Bristol case and whether that will hold up the discovery there.
Since Karen Reed filed a separate lawsuit, if any of those defendants move to dismiss the case, all discovery will stop in that case pending the result of that motion. That's why this attorney is concerned that perhaps discovery will be delayed because of those motions to dismiss.
That's the big unknown. I want to be clear that we're agreeing for discovery purposes to avoid prejudice.
But we'll get to the bottom of it. These are procedural niceties that are not going to inhibit our ability to move forward with our lawsuit, which is exactly what we want and what we need. Once we served our motion and we received their very, very assertive opposition, and you feel like it's not convenient.
Behind Alan is a portrait of the rarest animal in Africa, the rainbow elephant.
Not consistent with efficiency to do these things together, we'll just file on our own. Next thing you know, we go back to court and said they changed 180 degrees and said, well, wait a minute, I think we need to consolidate these things.
And behind our favorite lawyer here is even something more rare than the rainbow elephant, a hockey jersey from a Jewish player.
At least through the discovery process.
Discovery purposes.
We are tabling whether or not these matters need to be tried together. That will only be known once we have full understanding of what comes out in discovery.
That little jab of they're getting ready to file a defamation lawsuit against Karen.
Yeah. Well, threats are just that. They're just threats.
I just had one response. I've got 2 words.
Oy vey?
I'll bet I know what they are. Yeah, do it. Knock yourself out.
Have any depositions been scheduled yet?
I'm going to leave the civil procedure aspect of the case is being handled by Sheehan Finney back in Boston. I can assure you, from my perspective, are there depositions that I would like to be involved in? Yeah, you can imagine. I would. Yeah, I'm a long way from being done. I haven't exhausted all the questions that I have. I'll put it that way.
Yeah, I mean, like, it's just another thing in Massachusetts. If the Karen Reed case has done anything, you know, it's helped clean up a lot of the mess there. Sheesh, is this what happens every single day in Massachusetts?
That's what it feels like to me. I got to tell, I would love to have a coffee with your colleague who said it's not like this every day, because every day that I've been there, it's been like this. Yeah. The prism through which I view the Massachusetts justice system, I'm like gobsmacked and shocked every day.
Yeah, I think we all are.
If I could have just a moment, Your Honor, to confer with my client. The 16th and 17th don't work for Ms. Reed. Either the 18th, I know that's bad for Mr. Waters, the 19th would work.
At the end of the hearing, all the parties were trying to figure out a date for which they were all available. Alan was conferring with Karen during the actual proceeding, and this pissed off the judge.
Mary Jackson, I can understand Ms. Reed wants to be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
Different rules apply to civil cases compared to criminal cases. Here, generally, the individual parties don't have to appear or don't have a right to appear. Generally, they can appear through counsel, as opposed to a criminal case where generally the defendant has a right to be at every single hearing.
I agree. I'm not suggesting that she has a constitutional right to be there, but I know that she wishes to participate in her own defense, and she would like to be there if we can accommodate her schedule.
Right, but if the court starts having to accommodate every party's schedule, it would grind the courts to a halt.
What the judge is saying is correct. If the courts have to accommodate every individual that owns a corporation, for example, in this case, every single bar owner that's being sued, then they would never be able to schedule things timely.
I understand. I get that. There's only one defendant, though, for what that's worth.
There are other defendants in this case.
Yeah, but who cares about those other defendants? There's only one that really counts, Karen Reed.
Your Honor, for what it's worth, I can also do December 19th.
Thank you, Your Honor. I appreciate it.
And with that, the hearing ended without any final resolution as to whether any parts of the case are going to be consolidated. But to us, it doesn't matter if that Bristol case is consolidated with O'Keefe's initial case. We are not going to stop producing these videos until the real killer,
Brian Higgins.
is brought to justice.
Do you know what the term ghosted means?
I think I have a general idea, yes.
She sort of ghosted you, didn't she?
I wouldn't agree with that.
That was frustrating to you, that she just stopped communicating.
When I was young, I never needed anyone.
Wasn't it?
No, not at all.
All by myself. Don't wanna be all by.
You had been moving through this mindset of exploring a romantic interest with a beautiful woman, who thought was interested in you, and just like that, it was done. Right?
No.
Oh,